A few preliminaries to our program today. You should have been provided with the link to our written materials. If not, they're available on our website. Our written materials for the program today include copies of the PowerPoints, your very own copy of the HIPAA breach notification rule. I've also thrown in there a copy of the omnibus commentary to the omnibus rule commentary to the breach notification rule, because under the omnibus rule they changed the breach notification standards. And the best commentary we've got so far from the government, the best guidance we've got from the OCR concerning what is a breach, is this commentary. I've also given you a sample breach notification policy and an article on the new breach notification standard. This program will be recorded and available for download at our website. If you have any questions during the program, we probably won't be able to take them during the program, but you can just shoot me a quick email or use the chat feature and I'll respond offline. All right, today we're going to focus on HIPAA violations. We're not going to do a broad overview of HIPAA, or at least get into that in any detail, but we're going to focus on responding to HIPAA violations. Just remember that HIPAA preempts less restrictive state laws or other laws, but to the extent that there is a more restrictive state or federal law, you've got to comply with that other law. So in some of your states, like California and elsewhere, they may have more restrictive laws that you also have to comply with. In addition, a lot of you are probably execute business associate agreements. You may be business associates, and those business associate agreements may have more restrictive terms than are set forth in HIPAA. So you also have to look at your contract obligations. With that way of background, let's talk about HIPAA. Quick overview. There's three separate rules when you're talking about the privacy rules and the security rules. The privacy rule generally requires covered entities and business associates to protect the confidentiality of protected health information. It also gives patients certain rights concerning their information. There's a separate rule, the security rule, requires covered entities to implement certain safeguards to protect electronic protected health information. Now, if you have a violation of the privacy rule, not necessarily the security rule, but if you have a violation of the privacy rule, then you are required, under the breach notification rule, to give notice to individuals who are affected, the government, HHS, and in some cases, local media. We will talk about that extensively. The omnibus rule, as I mentioned, changed those reporting requirements. Why do you need to worry about this? Because of the HIPAA penalties, which are more draconian given the omnibus rule requirements. You can go to jail for HIPAA violations. The penalties for the criminal violations are anywhere from up to a $50,000 fine and or to $250,000 fine, and up to 10 years in prison, depending on your intent. That's probably not going to happen to many of you out there, but you do have to be concerned about the civil penalties. Under the civil penalty structure, there is this tier, and you get penalties depending upon the type of conduct involved. If you did not know and should not have known the violation, then the penalty is $100 to $50,000 per violation, up to $1.5 million per type of violation per year. Or if the violation is due to reasonable cause, it's $1,000 to $50,000 per violation. Okay, well that's bad enough, but there's some defenses to that. The real problem occurs is if you act with willful neglect. Because if you act with willful neglect, the OCR must impose a penalty. The penalties are mandatory. If you act with willful neglect and you correct it within 30 days, it's a mandatory fine of $10,000 to $50,000 per violation. If you act with willful neglect but fail to correct it within 30 days because you just don't like HIPAA or the horse it rode in on, then the penalty is at least $50,000 per violation, up to $1.5 million per type of violation per year. And by the way, those violations can add up awfully quickly. For example, if you lose a laptop that has 2,000 patients' names on it, that's 2,000 violations. In addition, if that violation resulted because you did not have appropriate policies, security rule policies in place or security rule protections, or you didn't encrypt, well, you were supposed to do that. That came out in the security rule back in 2005. For each day you fail to have those required policies in place, that is a separate violation. So those penalties can add up awfully quickly. That is the bad news. The good news is this. There is an affirmative defense to those penalties. 45 CFR 160.410 states that HHS may not impose a penalty on a covered entity or business associate for a violation if the covered entity or business associate establishes that the violation is not due to willful neglect, so you don't want to get anywhere near the willful neglect, and you correct within either the 30-day period beginning on the first date the covered entity or business associate knew or should have known that the violation occurred, or such longer time as HHS deems appropriate. The gist here is, hey, if you don't act with willful neglect and you correct that violation, that breach within 30 days after you knew or should have known of it, guess what? That's an affirmative defense to those HIPAA penalties. That is huge. So the question is, what's willful neglect? Willful neglect is defined as the conscious, intentional failure or reckless indifference to the obligation to comply with a HIPAA rule that was violated. HHS gave us the following example of willful neglect. A covered entity disposed of several hard drives containing electronic protected health information in an unsecured dumpster. That's a no-no. That's a violation of several HIPAA rules. And the covered entity failed to implement any policies and procedures to reasonably and appropriately safeguard that protected health information during the disposal process. The government said, hey, that's willful neglect. The covered entity had actual or constructive knowledge of their various violations. In addition, the covered entity's failure to develop or implement compliant policies and procedures or respond to incidents as required by the breach notification rule demonstrate a conscious intent or reckless disregard with response to their compliance obligations. What does that mean? That means they get hit up with a mandatory fine of at least $10,000 per violation. The key here to avoid willful neglect, you want to make sure you have your required policies in place, all of those policies and the safeguards that HIPAA requires you to put in place. You want to look at your policies and make sure you've got them in place. And if there is a violation, you want to make sure you jump on that immediately. You respond promptly and appropriately to correct the violation, because if you do, that can be an affirmative defense to the penalties. In addition, even if you fail to correct it, the government still may take into consideration your actions when determining the amount of the penalties. If you don't act with willful neglect, the government they have the discretion to reduce or eliminate the fees if they want to. If you act with willful neglect, you are subject to that mandatory penalty, the mandatory minimum of at least $10,000 if you correct it, $50,000 if you don't. Now that should be enough reason to comply with HIPAA, but if you needed more incentive, HIPAA also authorizes state attorney generals to sue you. They can sue you for a $25,000 fine per violation, plus you have to pay for their fees and costs. In addition, affected individuals may sue you. Now, there is no private cause of action under HIPAA, but HIPAA may effectively establish the duty of care or be used to establish negligence per se, and therefore they may rely on that to sue you. In the future, we will see proposed rules or draft rules that would allow affected individuals to recover a percentage of those fines or penalties, which creates an incentive for them to narc on you and to turn you in. Even if you're not worried about all of that stuff, you've got an affirmative obligation. A covered entity or business or a covered entity at least has to sanction employees who violate HIPAA, so you've got to be worried about your job. If you are a covered entity with a business associate to whom you've given the information and you know that that business associate is screwing up with the information, you as a covered entity have an obligation to act to stop that violation, or else you could be liable for HIPAA violations yourself. The covered entity may sue a business associate for breaching a business associate agreement, and HHS, we just received word within the last week that HHS is resuming audits of covered entities to determine your HIPAA compliance. Now, most of you aren't going to have HHS show up at your door just to conduct an audit out of the blue, but the OCR may contact you because of complaints. Why? Either a patient or an individual complains or an employee complains, but also you have an affirmative obligation to narc on yourself. You must self-report certain HIPAA violations. Certain violations you have to report to the individual if they request an accounting of disclosures. In addition, if you're a business associate, you have to report to the covered entity if you violate HIPAA or the business associate agreement, and you have to notify the patient or the individual, HHS, and perhaps local media if there's a breach of unsecured protected health information. We'll talk about each of those. Given all of that, you may feel a bit like this guy if you think you have a HIPAA breach. So what do you need to do if you think you may have a HIPAA breach? Now, what we're going to talk about mainly today are those situations where there's been an improper access, use, or disclosure of protected health information, not necessarily just the failure to put in place a policy. That may not result in a reportable breach, or it may be a violation, but not result in a reportable breach. We're going to be talking about the breach situations. So what is the first thing you do? You do not want to do this, because if you do, just remember that commentary from HHS. They said that that could be willful neglect, which means you could get hit up with those mandatory penalties. This is my 10-step cure, my paint by numbers for responding to potential HIPAA breaches. 1, take immediate action to mitigate any breach. If there's something that you can do immediately, maybe you sent that fax to the wrong address, you posted something improperly, take immediate action to cure that, as if there's something that you can do immediately. You want to stop that just as soon as possible. Next, immediately report the issue to your privacy officer. All of you who are covered entities must have a privacy officer. You must also have a security officer. If you don't, that's a violation of HIPAA. That privacy officer should be able to step in and help respond to any potential issues. You, as privacy officers, you need to train your staff to immediately report suspected breaches to you. You don't want them sweeping the stuff under the rug. Why? Because if they respond immediately and you jump on it, you may be able to avoid any, reduce the risk that the data has been compromised and avoid having to do any data report. And even if you do have to report the breach, you may be able to avoid the penalties. Remember, if you correct the situation within 30 days and you did not act with willful neglect, that is an affirmative defense to penalties. Even if you do have to do the report, you have to report within 60 days of when you knew or should have known of the violation. Now, under the guidance that came out, that 60 days begins to run not when the privacy officer learns about this, but it runs from the time that anybody in the organization, except the person who committed the breach, any other workforce member in that organization, when they knew or should have known about it, that's when that time limit starts running. So you want to make sure you train your staff to report immediately, and so that the privacy officer can then initiate an appropriate investigation. What should that investigation focus on? Well, first, as an initial matter, make sure that HIPAA applies to this situation. HIPAA only applies if the action is taken by an entity acting in its capacity as either a covered entity or a business associate. I've gotten calls from entities that say, hey, we get lots of protected health information, we get lots of data, health information about individuals, but they are neither a covered entity or a business associate. And if they're not a covered entity or business associate, they don't have to worry about this HIPAA stuff. A covered entity is a healthcare provider, but not all healthcare providers, only healthcare providers who engage in certain electronic transactions. In addition, a covered entity is a health plan, including an employee group health plan if it has 50 or more participants or is administered by a third party. Now, most of you are probably healthcare providers or business associates, but you are also, you may not know this, but your employee benefit plan may also be a covered entity. That means your employee benefit plan has to have the policies in place, has to put the safeguards in place to comply with the HIPAA stuff, just like the covered entity as a healthcare provider would have to do. If they don't, then they run the risk of HIPAA violations. In the wake of the HITECH Act and the Omnibus Rule, business associates now are also directly liable for HIPAA violations. A business associate is an entity that creates, maintains, transmits, or uses protected health information on behalf of a covered entity. So both covered entities and business associates need to be concerned about this stuff, but their duties are going to vary a little bit, and I'll talk about that. Next, assuming that you are a covered entity, you've got to ask, well, is the information disclosed or accessed, is it protected health information? Because HIPAA only applies to protected health information. What is protected health information? It's individually identifiable health information created or received by a healthcare provider or a health plan that relates to a person's past, present, or future health care or payment for their health care. It's not just medical records, it's payment records. And that information must either identify the individual, or there has to be a reasonable basis to believe that the information can be used to identify the individual. I've had some breach cases where somebody calls up and says, well, we had this situation, a doctor posted something on Facebook, but they never used the patient's name. However, they pretty much told everything else in the world about this particular patient, including the location where the patient got the services, the circumstances of the injury. So if anybody picked up the paper the next day, they would probably be able to relate that information back to that particular patient. That is probably identifiable information, even though they did not include the patient's name. Now, if you really want to be safe, you can de-identify the information. De-identified information is not protected health information. You de-identify information by going out and sucking out a whole list of data, individually identifiable identifiers from that data. And if you do that, it becomes de-identified and HIPAA no longer applies to it. It's things like names, addresses, URLs, a whole bunch of stuff. All right, so let's assume that you're a covered entity or a business associate and that this breach involved protected health information. What do you need to do next? You need to determine whether or not there really was a HIPAA violation. Just because somebody uses or discloses the information does not necessarily mean that there's a HIPAA violation. It would be a HIPAA violation if they use, access, or disclose the information, presumably, unless they fit within one of the HIPAA exceptions. The general rule under HIPAA is, hey, you cannot use, access, or disclose protected health information without the patient's written authorization unless you fit within an exception. What are some of those exceptions? There's an exception for the use or disclosure for treatment, payment, or healthcare operations. That is very broad. That's most of your uses or disclosures of your information. But even that can be limited if you tell the patient that, hey, even though HIPAA allows us to use or disclose this information for treatment, payment, and healthcare operations, we're going to agree to place additional restrictions on that. If you place additional restrictions on that, then you've got to comply with those. And if you don't, then that would be a HIPAA violation. That would be a reportable breach, presumably. There's also an exception for disclosures for use in a facility directory of certain information, if that disclosure is limited to certain information, or disclosures to family members or other persons involved in the healthcare or payment of the healthcare if the patient did not object to such disclosures. There are a whole bunch of exceptions that are listed in 45 CFR 164.512. Most of these deal with disclosures for government purposes or by certain agencies or for certain public safety protections, or disclosures that are otherwise required by law. Generally, unless you can fit within one of those exceptions, you've got to have a valid written HIPAA-compliant authorization to use or disclose the information. That use or disclosure of information is also a violation if it's done by business associates or the agents of the covered entity. So the covered entity would not only need to respond to its own breaches, but also address breaches by its business associates or its agents, members of its workforce. Now, HIPAA, you can also have a HIPAA violation by not only disclosing information you shouldn't have, but also disclosing more information than you should have. So even though HIPAA would allow you to make disclosures under one of these exceptions, if you disclose more than the minimally necessary for a particular purpose, the government says, hey, that's also a HIPAA violation. And you'd have to do a breach report or at least go through the analysis and the like. A lot of people forget this minimum necessary requirement or this standard. Maybe that's one of the most common breaches that is out there. Nevertheless, it is there, and technically that would be a breach that would have to be reported if it otherwise satisfies the breach notification standards. Now, that minimum necessary standard does not apply to disclosures to a request by another healthcare provider. We don't want you to be in a situation where you have to second guess whether that other healthcare provider really needs that information. It does not apply to disclosures made per an authorization. Just make sure you limit the disclosure per the authorization, or to use of disclosures required by law. Just make sure you're limiting the disclosure to the extent that that disclosure is required by law. Now, HIPAA realizes that, hey, we cannot perfectly protect all information, and sometimes people just overhear. And so there's what are called incidental disclosures. Incidental disclosures do not violate HIPAA, and therefore they're not reportable. What's an incidental disclosure? It's a disclosure that's incident to a use or disclosure that is otherwise permitted or required under the rule. So maybe you're making a disclosure for treatment purposes, but somebody just happens to overhear. That's not a violation so long as you put in place reasonable safeguards to protect against those improper disclosures, and you don't disclose more than is minimally necessary. That is a potentially big deal. That's the exception. These incidental disclosures, those are the things that occur most frequently, and this is the exception that allows you from having to do breach notifications of all of those incidental disclosures. An incidental use or disclosure is a secondary use or disclosure that cannot reasonably be prevented, is limited in nature, and that occurs as a result of another use or disclosure permitted by the rule. For example, as I mentioned, a hospital visitor may overhear another provider's confidential conversation, or a hospital visitor may walk down the hall and see some information up on a whiteboard. As long as you put in place reasonable safeguards, those types of incidental disclosures are not breaches and don't have to be reportable. They're not HIPAA violations. Reasonable safeguards could be things like, hey, you ought to speak quietly to avoid those types of incidental disclosures. You shouldn't discuss, generally, public patient information in public areas. Don't disclose patients' names in public areas. Isolate or lock file cabinets, those types of safeguards can protect you in the case of incidental disclosures. When that privacy officer is doing the investigation, they should confirm the facts with the persons involved. Obviously, they're going to talk to witnesses, but they may or may not. I've seen privacy officers who never got around to talking to the person who's allegedly did the disclosure, or even the person who may have received the improper information. The privacy officer wants to talk to those people for several reasons. One, to confirm the reason for the disclosure. Two, to confirm the scope of the disclosure. Three, to confirm whether somebody else really actually got that information, and determine what else needs to be done to avoid any further HIPAA violations. Once the privacy officer initiates that investigation and identifies potential steps that need to be taken, you have an affirmative obligation to act promptly to mitigate any harm. The privacy rule specifically says that a covered entity must mitigate to the extent practicable any harmful effect that is known to the covered entity of a use or disclosure by the covered entity or its business associate of protected health information in violation of its policies or the privacy rule. You have an affirmative obligation to mitigate. As I mentioned earlier, if a covered entity or business associate knows of a pattern or practice of a business associate or a subcontractor that violates HIPAA, that covered entity or business associate has to step in and take steps to cure that breach or end the violation. If they can't do it, they've got to terminate the business associate agreement. If they fail to do so, that covered entity or business associate is liable for a separate HIPAA violation. So what are some things that you may want to do to mitigate any harm? Well, obviously you want to stop any further breaches. You want to make sure no additional information is going out. You want to retrieve, delete, and or destroy any protected health information that improperly went out. So if you sent that fax, you want to contact that recipient as soon as possible to make sure that they destroy the fax, that they don't look at it, that they return it to you, whatever it is that you need to do to make sure that there is not going to be a further use or disclosure. You want to contact that recipient to make sure that they don't disclose the information further and to warn them about the penalties if they do. If you do that and if you document it, that can help show that, hey, we warned this person about further disclosures. It's not our fault if they disclosed it beyond there. You want to terminate access, change passwords, etc. Especially in this day of mobile devices, laptops and the like, if you've got the capability to do a remote wipe of those hard drives, that can be a huge benefit to you. A lot of the big ticket security penalties that have come out have been because of lost mobile devices or laptops. And if you can make sure that you can remotely wipe those hard drives, that can protect you. Now, you may want to notify affected individuals in order to mitigate damages. You're not necessarily required to, but there may be circumstances where you want to in these situations to mitigate potential harm they may suffer. For example, you may want to cover the cost of additional measures such as credit reporting agencies providing or paying for that. I don't know how many of you were affected by the Target security breach, but I got my little notices telling me that they would pay for the cost of a credit reporting agency, and I've seen that. That's fairly standard in some of these serious breach cases. When you're doing that, though, taking those actions, you want to make sure you document that so that you can explain it to the government if they ever come back. You can show that you took immediate steps to mitigate the damages. Next, you need to sanction employees. The privacy rule specifically says the covered entity must have and apply appropriate sanctions against members of its workforce who fail to comply with the privacy policies of the covered entity or to violate the HIPAA rules. And you've got to document those sanctions. Now, the sanction you impose can fit the crime. It could be anywhere from a written warning to termination to turning them over to the police or the Department of Justice or the OCR. The sanctions may depend on the person's intent, the seriousness of the breach. Is this a first-time offense or is this repeated misconduct or any other relevant factors? HIPAA doesn't say that you must impose this particular sanction. You just need to be able to document that you put in place appropriate sanctions. You may want to check your employee policies to ensure that they are consistent with the sanction requirements under HIPAA. Next, you need to correct the violation. This is incredibly important. Why? Remember, I began this presentation by talking about the affirmative defense to penalties. It is an affirmative defense to HIPAA penalties if the covered entity or business associate did not act with willful neglect and you correct the violation within 30 days. So you definitely want to take steps to correct the violation. Now, how does one do that? I mean, once that information's out, it's out, right? You can't unring the bell. But the government has said that they interpret corrected broadly. For example, in the event of a covered entity's or business associate's non-compliant, inadequate safeguards policies, if that results in an impermissible disclosure, the disclosure violation itself could not be fully undone or corrected. You can't unring the bell. But the safeguards violation, however, could be corrected in the sense that the non-compliant policies and procedures could be brought into compliance. So what are some things that you want to do to correct a violation? Well, you need to mitigate the harm and sanction your employees. That's part of correcting the violation. We already talked about that. But you also need to step in and take a look at your policies. Did this breach result from an improper or inadequate policy? Do you need to revise or update those policies or change those policies? Do you need to implement new or different safeguards to protect against such breaches in the future and correct the past violation? Do you need to train your personnel concerning these situations? That training is very important for reasons we'll talk about in a minute. You need to make sure you're enforcing your policies and rules. You may want to contact or notify affected individuals. That may be part of correcting the violation, but it's not technically required, at least under this rule. Well, you may want to take what other appropriate steps need to be taken in order to show the government that, hey, there was this violation, yeah, but we stepped in immediately. We took this corrective action. And you're going to want to document your actions so that you can show it to the government if they ever show up. Next, this is a step that's often forgotten. Remember, under the privacy rule, a patient has a right to request an accounting of certain disclosures of their information by a covered entity or business associate made during the prior 6 years, including disclosures in violation of HIPAA or disclosures for certain government functions. If you have those improper disclosures, that patient can come into the covered entity and say, hey, I want an accounting of my disclosures. And in that case, you would have to give them a log or an accounting of all of these improper disclosures that you've made. That would necessitate that you maintain that log as you go along. Now, you only have to log disclosures, improper disclosures in violation of HIPAA or under these government functions exceptions. Disclosure is defined as the release, transfer, provision of, access to, or divulging to any in any other manner of any of information outside the entity holding the information. So you're supposed to be tracking these improper disclosures. You're supposed to log the date of the disclosure, the name and address of the entity who received the information, a brief description of the information disclosed, a brief statement of the purpose of the disclosure, a copy of the written request for disclosure. If you have a series of disclosures to the same person, you can get a summary and kind of combine that stuff. As a practical matter, I suppose you could wait and try to create that at the end when you get that request for an accounting, but how are you going to remember disclosures that were made, 6 years prior? So as a practical matter, you should be maintaining this log. Now, that's as a practical matter. I've been doing the HIPAA stuff since 2003 when HIPAA came out. I think in all that time, I've only heard of maybe 2 or 3 different requests for accounting of disclosures. It just doesn't happen very often, and that's probably why, if you go back and look at your organization, you probably do not have a very robust method or process for logging these disclosures for purposes of the accounting rule. Nevertheless, that's part of the rule, and if you don't do that, then technically you're violating the rule. There is a proposed rule in the wake of HITECH Act that would expand that accounting of disclosure requirements to also not only require you to disclose those improper HIPAA disclosures, but also to render an accounting of any disclosures you make for treatment, payment, or healthcare operations if you maintain an electronic health record. Actually, the proposed rule is broader than the HITECH Act and would require even broader reports. Now, that is a proposed rule. We don't have the final rule yet. You'll have to watch for that and see if that's going to change this. Now, the good news of all of this accounting of disclosure stuff is that under this rule, you only have to account if the patient asks for that, and patients simply don't ask for that very often. But again, you're running a risk if you're not maintaining that log. When you do that accounting, remember that you also have to account not only for the disclosures that a covered entity makes, but also disclosures that covered entity's business associates may make. All right, step number 9. You've done your investigation, and then you need to determine whether or not you have to make a required report. Now, for business associates are required under both HIPAA and the Business Associate Agreement to report certain information to the covered entity. Specifically, business associates under the HIPAA rule must report to the covered entity any use or disclosure of protected health information that violates HIPAA or which violates the Business Associate Agreement if the business associate becomes aware of that. Now think about that for a minute. We'll talk about the breach notification in a minute, but this rule requires business associates to make reports of breaches to the covered entity even if it's not otherwise reportable to the individual or the government. In addition, this rule not only requires the business associate to report HIPAA violations to the covered entity, but that business associate also has to report disclosures, unauthorized use or disclosure that violates the Business Associate Agreement, even if it doesn't violate HIPAA. So you as business associates, you're going to want to take a look at those Business Associate Agreements and make sure that they don't require you to make reports that would not otherwise be required by HIPAA. In addition to those disclosures, the HIPAA rules require that business associates report to covered entities any security incident of which it becomes aware. And security incident is defined as the attempted or successful unauthorized access, use, disclosure, modification, or destruction of information or interference with the system operations. Now, note that it's not only those successful unauthorized access, but it's also the attempted unauthorized access. If you read this literally, that means that you have to report to the covered entity every time that you've got those unsuccessful pings or port scans or all of those nasty things that are always going on in the background that you protect against because you've got the firewalls and those other security rule protections. That is a bit problematic, and we're hopefully going to get some additional clarification for the government where they say, oh yeah, okay, you don't have to report those attempted security breaches, only the actual successful security breaches. In the meantime, technically you're supposed to report that. Most of the time, the way we handle that is in your Business Associate Agreement. Just confirm that you give them notice that those occur all the time, that the business associate agreement itself constitutes sufficient notice of that, and that you don't have to give continuing notice of these unsuccessful attempts. So far, the government hasn't seemed to have a problem with those types of provisions. Okay, those are two situations where business associates have to give notice of breaches. They also have to give the covered entity notice if there is a breach of unsecured protected health information per the breach notification rule. I'll come to that in just a minute. Just remember that in your business associate agreements, a lot of them will put in place more strict requirements than are required by HIPAA. So you want to check your business associate agreements to see if they require additional breach notification reporting or additional standards, lower standards for making reports to the covered entity. That brings us to the breach notification rule. The breach notification rule says that if there is a breach of unsecured protected health information, the covered entity has to notify each individual who's affected. They also have to notify HHS, and in some cases they have to notify local media if the breach involves more than 500 persons in a state. So the covered entity has to notify those individuals. The business associate, if they discover a breach, they have to notify the covered entity so the covered entity can do the breach notice. Note there that you only have to give the breach notification under this rule to the individual and to HHS if there are two conditions that are satisfied. First, it has to be a breach, and second, it has to be a breach of unsecured protected health information. Let's talk about each one of those. What is unsecured protected health information? Well, it's information that's not secured. Well, how do you secure information so it's not unsecured, so you don't have to give notice of a breach? There are currently only two ways to secure your protected health information. If it's electronic data, you have to encrypt it, and that encryption has to satisfy certain standards. If it's not protected health information or paper information or the like, you have to destroy it, meaning paper, film, or hard copy media is shredded or destroyed such that the protected health information cannot be read or deconstructed. You could also destroy protected health information, make sure that it's cleared, purged, or destroyed consistent with NIST standards. Simply wiping a hard drive may or may not actually protect it because a lot of the stuff may be there. So you should check and make sure that your security policies are adequate and you are having sufficient process for protecting against health information. There was a recent case against a copier company or an entity that actually returned copiers, and those copiers were not sufficiently wiped to their hard drives, and that resulted in hundreds of thousands of dollars of penalties being paid because they failed to have in place the appropriate HIPAA policies. All right. So most of the stuff you're going to be dealing with is going to be unsecured protected health information. Then the question is whether or not there is a breach of unsecured protected health information. A breach under the new omnibus rule, it states that the acquisition, access, use, or disclosure of protected health information in violation of the privacy rules is presumed to be a breach unless the covered entity or business associate demonstrates that there is a low probability that the information has been compromised based on a risk assessment. So note the elements here. First, there has to be an acquisition, access, use, or disclosure of protected health information. Okay? And that access, use, or disclosure has to violate HIPAA, meaning it has to violate one of the privacy rules. If that occurs, it's presumed to be a breach unless you can demonstrate that there is a low probability that the information has been compromised based on a risk assessment of the following factors: the nature and extent of the information involved, that the unauthorized person who used or received the protected health information, whether the information was actually acquired or viewed, and the extent to which the risk to the information has been mitigated. That is the standard. That's the risk assessment you do to determine whether or not there's a low probability that that has been compromised. That all applies unless an exception applies. HIPAA has certain exceptions to the definition of breach. There are three exceptions. The unintentional acquisition, access, or use by a workforce member that was made in good faith within the scope of their authority and the information is not further disclosed in violation of HIPAA or the privacy rule. This is a situation where somebody, maybe a nurse, goes in there and types in patient John Smith to call up and get their information, only to find out, oh, wait a minute, this isn't the right John Smith. Well, they didn't properly access the information, but it was unintentional. It was done in good faith, and as long as they don't further disclose that information, that is not a breach under the privacy rule, and you do not have to report it. Second exception, the inadvertent disclosure by an authorized person to another authorized person of the same covered entity, business associate, or organized healthcare arrangement, and the information is not further used or disclosed in violation of a privacy rule. So this is a situation where maybe somebody comes up and calls out to the nurse, hey, you're the nurse who's taking care of patient John Smith, right? I want to talk to you about that, and goes on to disclose information only to find out that they're talking about the wrong John Smith. As long as it's an inadvertent disclosure by an authorized person to another authorized person and it's not further disclosed, that's not a reportable breach. The third one is kind of interesting. That says it's not a breach. The following is not a breach. The disclosure of information where the covered entity or business associate had a good faith belief that the authorized person receiving the information would not reasonably be able to retain the information. What does that mean? Does that mean if that person receiving the information has short-term memory problems, then we don't, it's not reportable? Well, we don't know exactly. The example they gave is you've got a nurse that comes out, is handing out discharge instructions, gives the discharge instructions to the patient, only to realize, oh my gosh, that's the wrong patient, immediately grabs it back before that person has a chance really to read it. Or maybe you send out information, a bunch of EOBs, to the addresses, and a bunch of those EOBs are returned unopened. In that situation, you conclude that the person, the recipient, did not or would not reasonably be able to retain the information. Okay, those are situations that are excluded from the definition of breach, so they are not breaches under the rule. Well, the real standard, the real test for most situations is there a low probability that the data has been compromised? Well, what does that mean? Does compromised mean that the information is acquired, accessed, used, or disclosed? Simply the fact that you disclose the information, does that mean the data has been compromised? Well, they don't define what compromised is, but I don't think simply the fact that it was acquired, accessed, used, or disclosed mean that it is per se compromised. There may be a presumption, but it is not per se compromised. The government in the commentary that I've given you recognized that requiring notice in all situations where PHI was accessed, acquired, used, or disclosed would be too burdensome and would unduly trouble patients. HHS noted that there are situations in which unauthorized acquisition, access, use, or disclosure of information is so inconsequential that it does not warrant notification. And furthermore, whether the information was actually acquired or viewed is only one factor in that risk assessment. So simply the fact that the information was accessed, used, or disclosed does not necessarily mean that the data has been compromised. Well, if that's not the test, does compromise mean that the acquisition, access, use, or disclosure would result in potential harm? Are we back to the harm standard that we had before the omnibus rule? No, I don't think so, because HHS has repeatedly affirmed that it was removing that harm standard. They thought it was too subjective. But at the same time, they noted that considering the type of information involved in the impermissible use or disclosure will help entities determine the probability that the information could be used by an individual, by an unauthorized recipient in a manner adverse to the individual or otherwise used to further the unauthorized recipient's own interest. What does that mean? That sounds like harm, doesn't it? So what are they really talking about? What does compromised mean? Well, the bottom line is, who knows? We haven't got a lot more direction from the OCR. So I guess we're left with the dictionary definition of compromised, which means to expose to suspicion, discredit, or mischief, to reveal or expose to an authorized person, to expose or make liable. What does it mean? I guess when you take all this stuff together, the net effect is probably compromise for purposes of the breach notification rule probably means both that there's a potential for an unauthorized access, acquisition, use, or disclosure, so that there is this potential, but also not only that there is that potential, but also there's a potential for some kind of misuse of the information. The focus seems to be on actual or potential misuse of the information, not necessarily subjective harm to the individual. Hopefully we will get further guidance from the government on what they mean concerning compromised, but we haven't yet. So, you've got that definition. You've got a breach of unsecured protected health information, and the test is to determine whether or not there's a low probability that the data has been compromised, whatever compromised means. How do you tell whether or not there's a low probability? Well, you do the risk assessment based on the following factors. First is the nature and extent of the information involved, including the types of identifiers and the likelihood of re-identification. What does this mean? Well, did the data that was disclosed, did it have sensitive financial information like social security numbers or account information? Does it contain a PIN? Does it contain sheer volumes of information so that it may not only have the patient's name, but also a bunch of data concerning the type of information that they are receiving? In the original breach notification rule, the government gave the example that simply the fact that a patient's receiving care at a hospital probably would not trigger the breach notification rule, at least under the old standard. However, if you got the patient's name along with records that shows what type of care they're receiving or those types of information, that mitigates towards pushing it over the edge so that the data is compromised. Second factor, look at the nature of the person who used or received the information. If they are a doctor or somebody else who's already or otherwise covered by HIPAA and obligated to maintain the confidentiality, there's not the same risk as if it's just some Joe Schmo down at the local tire store, or some mechanic, or some loan shark, or something like that. Third factor, whether the information was actually acquired or viewed. If you could show that it was never acquired or viewed, then that probably shows that there is a low probability. On the other hand, if you can't show that it was not accessed or used, then there's a higher probability that the data has been compromised. The extent to which the risk to the information has been mitigated. Were you able to jump on top of this so that, yeah, you realized you sent that fax to that other physician's office, but you immediately contacted that other physician and confirmed that they didn't look at the information? Or you sent it to the tire company and you immediately contacted that tire company and they confirmed that they didn't access or read the information. If you mitigated it, took immediate steps, then that would suggest that there's a low probability that the data has been compromised. The government said these aren't necessarily all the factors that you can consider. You could consider additional factors, but you start with at least those 4 factors. Now, what happens if you don't want to do that risk assessment? It's just too hard. We don't want to do it. We'd just rather make the report. That's fine. You can go ahead and do it. You only have to do that risk assessment if you don't want to make the report. Now, the government has given us a little bit of guidance concerning what these things mean, what compromise means, what's a low probability. They gave us some examples in the commentary. For example, if you send the fax to the wrong physician, but the physician reports the fax and confirms he's destroyed it, well, that's probably a low probability that the data has been compromised. If the disclosure is to or used by persons who are required by HIPAA to maintain confidentiality, then again, that's probably a lower probability that the data has been compromised. Was the disclosure without identifiers or to an entity that lacks the ability to re-identify the information? If so, that's a low probability. Was there a stolen laptop and you recover it, but an analysis shows that the information was never accessed? Then all of that suggests that there's a low probability. But even then, the government says, hey, you can't take any one factor, you got to look at all the factors. Well, on the other hand, what are some situations that create a higher probability that the data has been compromised? The government gave us these examples. If the disclosure involves financial data like social security numbers, credit card numbers, that type of stuff, sensitive information like STDs, HIV, mental health, or other information, or detailed information like treatment plan, diagnosis, medication, medical history, test results, that suggests that mitigates and suggests that there is probably not a low probability the data has been compromised. If the disclosure involves a list of patient names, addresses, hospital IDs, or if the information is mailed to the wrong individual who opened it and read it, and that person is not a covered entity or business associate, that suggests that the data has probably been compromised. But again, you have to look at all of those factors. The government has promised to issue future guidance on common situations, but we haven't really got that yet. In the meantime, we're stuck with the current standard. Here's kind of the net effect. The general rule is if there is the unauthorized access, use, or disclosure of unsecured protected health information is presumed to be a data breach unless you can satisfy these criteria. You do not have to do the breach notification if there was no privacy rule violation. For example, it was an incidental disclosure that did not violate the HIPAA rule. You don't have to do the breach notification if the PHI is secured, if it's encrypted per HHS standards. You don't have to do it if an exception applies, one of those 3 exceptions we talked about. And finally, you don't have to do the breach notification if you can demonstrate that there's a low probability that the data has been compromised based on that risk analysis, those 4 factors we just talked about. Remember, the covered entity has the burden of proving any of those. If you're going to not make the report, you're going to have to be the one who's going to prove that the report was not required. So until we receive further clarification, it's safer to err on the side of reporting all but clearly inconsequential breaches, because that low probability standard is probably a pretty doggone low standard, especially given the fact that you've got the burden of proving the low probability that the data has been compromised. In addition, the failure to report may be viewed as willful neglect, resulting in mandatory penalties. So if you guess wrong and the government comes in there and says, no, you should have made the report, that may evidence willful neglect. The government gave the following example of willful neglect. A covered entity's employee lost an unencrypted laptop that contained unsecured information. The covered entity feared its reputation would be harmed if the info about the incident became public and therefore decided not to provide notification as required. What does that mean? If you've got a breach and you decide you're not going to do the breach reporting, and unless you have an awfully good case, the government could very well find that's willful neglect. That means mandatory penalties of at least $10,000 per violation. That's if you correct it within 30 days. But if you decided not to make that report, you probably didn't correct it, and that means that could be mandatory penalties of at least $50,000 per violation. Just a quick word while we're talking about that hypothetical the government gave. When it comes to missing protected health information, particularly missing USBs, missing mobile devices, missing laptops containing protected health information, the OCR pretty much takes the position, hey, that data has been compromised, you need to do the report, unless you get that stuff back and show that you do that forensic analysis and confirm that it wasn't accessed. Even though you don't think, even though you have no reason to think that that missing USB fell into nefarious hands, simply the fact that you don't know where it's at, if it's unencrypted, the government appears to require you to make those reports. And if you fail to do that, that could potentially be willful neglect and result in serious penalties. So when it comes to breach of unsecured protected health information, you've got kind of a tough choice. On the one hand, if you go ahead and do the breach report because you want to play it safe, that may reduce your risk of significant penalties because you're probably going to avoid willful neglect and mandatory penalties, and even if the government imposes penalties, the penalties won't be so bad. On the other hand, if you do that breach report because you're trying to play it safe, just realize that that increases the risk. You're probably going to get an OCR investigation. When that OCR comes in and does the investigation, unless you otherwise had your HIPAA ducks in a row, the government could find that there were other policies and procedures you didn't have in place that resulted in that breach. And the government can tag you for failing to have those policies and procedures in place. So doing that report opens you up to that further investigation, patient complaints, AG suits, or simply the cost of doing the breach reporting that we're going to talk about in just a minute. So you're kind of in that situation where you're damned if you do, damned if you don't. So you need to seriously consider in those gray areas of whether or not you're going to make the report, what are the potential consequences one way or the other. Probably the safer thing to do is to err on the side of doing the breach notification, which brings us to what do you do? If there's a breach of unsecured protected health information, the covered entity has to notify each individual whose information is affected. You've also got to notify the HHS, local media in some circumstances. The business associate has to notify the covered entity. How is that done? Well, let's talk about notice to the individual first. You've got to provide that notice without unreasonable delay and in no case later than 60 calendar days after you knew of or should have known of that breach. As I mentioned earlier, you are deemed to have known or should have known of the breach from the time that any of your workforce members knew or should have known except the person who committed the breach. That 60 days does not run from the time that administration learns of this. It runs from the time that anybody knew of this except the person committing the breach. Again, you need to train your people to report promptly. In addition, that 60-day period, it's not a true 60-day period. Basically what they say is, hey, you're supposed to do this breach as quickly as you can without unreasonable delay. That means if you can do the investigation and you can make that report within 2 weeks, you ought to be doing it in 2 weeks. You can't wait for the 60-day period. It's just no later than 60 days. But if you can do it earlier, you're supposed to do it earlier. What does that notice have to contain? You've got to tell the individual the following. You've got to give them in writing a brief description of what happened, including the dates of the breach and the discovery, a description of the types of unsecured protected health information that were involved. You've got to give them the steps, tell them the steps they should take to protect themselves from harm resulting from the breach, a brief description of what the covered entity is doing to investigate, mitigate, and protect against future breaches. You've got to give them contact procedures so that they can contact you to ask questions, including toll-free number or email address, website, or postal address, that they can contact you to get information about that breach. How do you give that to them? You got to send it to them by first-class mail to their last known address. Simply calling them up and telling them on the phone is not enough. Even if it's the patient who filed the complaint with the OCR, so they obviously know about it, you're still expected to give this written notification. I guess this is the way of the government's making sure that they're going to keep the post office in business. If the individual is deceased and the covered entity has an address for next of kin or the personal representative, you ought to give that notice. You have to give that notice by first-class mail to the next of kin or personal representative. If it's an urgent situation, you can also contact the patient or use other means to contact them, but that doesn't exempt you from the obligation to give written notice to that patient. If you lack sufficient contact information to provide that written notice, you've got to provide substitute notice. The type of substitute notice is going to depend upon the number of persons affected. If it's less than 10 such persons that you lack that information for, then you can use alternative forms of written notice such as or telephone or other means like email or the like. If it's 10 or more such persons, if there's 10 or more people you can't track down, then you've got to use a different form of alternative communication. You've got to conspicuously post on your website information about the breach for 90 days, or you've got to give a notice in a major print or broadcast media where the affected individuals are likely to reside. For heaven's sakes, when you do those notices, make sure that you're not posting any protected health information about these individuals. You've also got to include a toll-free number so that those persons can contact you for 90 days. Okay, that's the breach to the individual. Anytime you give the breach to the individual, you've also got to notify the government. The only difference is the timing. If the breach involves fewer than 500 persons, if you want to, you can wait and submit your reports to the government annually. You've got to do that no later than 60 days after the end of the calendar year. So for 2013, your deadline is, what, day after tomorrow? You've got to do it by March 1st. If the breach involves 500 or more persons, you can't wait to do it next year. You've got to do it at the same time, contemporaneously with the notice to the individual or next of kin. That means without unreasonable delay, but within the 60-day period. Now, even though you can wait until the next calendar year to give that notice, as a practical matter, that's pretty hard because you don't go in there and just give one notice that includes all of these breaches. You do a separate breach report for each one of your breaches. For those of you who've done that, that can be a bit time-consuming and it requires a lot of detailed information. That will be somewhat difficult to just collect that and do that all at one time by March 1st. So you may want to actually give these breaches as you go along. The way you give that report is you go to that website, the government has a little tab there, you click on that, and you go into that electronic breach notification report form. If the breach involves more than 500 persons, you're added to the HHS's wall of shame. They post your information up there on the government's website, just like that stuff there. That's the notice to the government. In certain circumstances, you have to call up Channel 7 or the local news station or the newspaper to report breaches. If the breach involves unsecure protected health information of more than 500 residents in a state, you've got to notify prominent media outlets serving that state. You've got to do that without unreasonable delay, but no more than 60 days from the discovery of the breach. And generally, you have to include the same content as the notice to the individual. Just for heaven's sakes, make sure you don't include any individually identifiable information. Business associates, they have to notify the covered entity. The rule requires them to notify the covered entity within 60 days. As a covered entity, you probably want to put in your business associate agreement some requirement that requires the business associate to report more promptly than 60 days. That notice has to include certain information, if to the extent that the business associate has it, including the identification of individuals affected and any other information that's required for the covered entity to give its required notice. Law enforcement can come in certain circumstances and require you or ask you to delay giving that notice. That doesn't happen very often. So, briefly to summarize, if you think you have a potential breach, act immediately to minimize that breach. Do what you can immediately to mitigate the effects. Notify the privacy officer as soon as possible. Conduct an appropriate investigation to determine whether there is a breach and the extent of the breach and what you need to do to mitigate the harm. Then, mitigate any harm. Sanction your workforce members. Correct any process that resulted in an improper disclosures, which could include changing your safeguards, changing your policies, training your personnel. Do a report if it's required, a report to the covered entity if you're a business associate, or a report to the affected individual, and HHS if it's required by the breach notification rule, and document the foregoing. Remember, in all of this, prompt action may allow you to satisfy your duty to mitigate, avoid disclosure and breach reporting obligations if that action, that prompt action, results that there's a low probability that the data has been compromised. If nothing else, it will show that you corrected the action within 30 days and you can defend against HIPAA penalties. To determine if a breach is reportable, ask yourself, was there the non-authorized access, use, or disclosure of unsecured information? Did it violate the privacy rule? Does one of the exceptions apply to breaches? And if all of those are yes, is there a low probability that the data has been compromised based on your risk assessment? You're going to be expected to document all of the following. All right, that is a quick overview of responding to possible HIPAA violations. But remember, a good offense is always your best defense. Your best defense against breach violations is to act to minimize your exposure before a violation occurs. So take preventative steps. You're all going to have breaches. The question is whether or not that breach is going to result in penalties. These are some steps you can do to make sure that breaches don't result in penalties. First, know the rules. Second, implement the required policies and safeguards, then train your employees regarding the policies and safeguards. Important safeguard is to execute confidentiality agreements and business associate agreements. Business associate agreements are required. Confidentiality agreements are not necessarily required, but they are great evidence if you need to show the OCR that you took appropriate steps to safeguard the information and your employees knew that they should keep it safe and they just went rogue. And you want to respond immediately if there's a suspected breach and document all of the foregoing. Why is that so important? Because if you do that, the government has said, hey, if you do that, that is not willful neglect. And you're not responsible even if a rogue employee commits a breach. They gave the following example. A hospital employee accessed the paper medical records of his ex-spouse while he was on duty, knowing that such access was not permitted by the privacy rule and contrary to the policies and procedures of the hospital. The covered entity had appropriate and reasonable safeguards regarding the employee access to medical records, and it had delivered appropriate training to the employee. And in that situation, the government said, hey, that's not willful neglect. What does that mean? That means if you correct a situation within 30 days, that is an affirmative defense to any penalties. Again, the bottom line here, make sure that you've got the required policies in place. Make sure that you train your personnel, respond promptly to any breach. If you do that, you can avoid HIPAA penalties. Now, if the OCR comes in and does an investigation, a couple of steps, a couple of suggestions. You may want to consider contacting a knowledgeable healthcare attorney, because somebody who knows about HIPAA, because sometimes there really wasn't a breach. There's an exception that applies, or they may be able to respond in a way to confirm that there was no breach, or if nothing else, that there was no willful neglect. Cooperate with the OCR, but be careful what you disclose. Just make sure that you respond appropriately. So far, the biggest HIPAA penalty that's been imposed, well, one of the HIPAA's biggest penalties that was imposed, it's a $3 million fine against an entity, not necessarily because of a breach, but because the entity refused to cooperate with the OCR. When you respond to the OCR will normally send you a letter saying, hey, we got this allegation of a breach, we want you to send you the following information. When you respond, don't just send them the information they asked for, but take the opportunity to explain your position and the facts. Explain that you had appropriate policies in place. Explain that you did appropriate training. Explain that the employee violated your policies and training. You did what you should have, but this guy just went rogue. Explain that you responded immediately and appropriately to mitigate the harm and to take appropriate corrective steps. Cite the commentary and the rules that I've given you in this stuff, confirming that, hey, no penalties are appropriate in these situations because you did not act with willful neglect and you corrected the situation within 30 days. I have responded to the OCR on numerous occasions, and so far, none of my clients have ever been subject to HIPAA penalties because we were able to show that we complied with, we had in place the required policies, we took appropriate corrective action, we trained our people, and because of that, there was no willful neglect. All right, that summarizes what you need to do to respond to potential HIPAA breaches. Some additional resources. The government maintains an extremely helpful website that contains a whole bunch of information. Our firm has a bunch of additional stuff if you have interest, including training programs dealing with HIPAA privacy and security that you can access for free at our website. We also have sample HIPAA documents, including sample policies. Those policies I referred to that you should get in place. If you need copies or would like copies of those, I can make those available for a small charge. You can contact me if you have an interest. Otherwise, no problem. And that's it. If you have questions about anything that we've talked about, feel free to use that chat feature and send them to me, or send me a quick email offline. Otherwise, thanks very much for your participation. We appreciate it. If you'd like to participate in future webinars, send us an email. We'll sign you up for the list, and you can get information on those future webinars. Thanks very much. Hope you have a good day and a good weekend.